Good afternoon. Thank you for coming. My name is Shifa Abu Zaid, and I am the president of Penn State Law's American Constitution Society, also known as ACS. For those of you that may not be familiar with ACS, it is a national network of lawyers, law students, scholars, judges, and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping debate on vitally important legal and constitutional issues through the development and promotion of high-impact ideas like the panel we will be hosting today. I will be introducing one of our speakers that we are very lucky to have here at Penn State Law tonight. It is my pleasure to introduce Professor Kitrosser, a Robbins Kaplan Professor of Law at the University of Minnesota Law School. She is a constitutional law expert who focuses on federal government secrecy and separation of powers and free speech. Her book, Reclaiming Accountability, Transparency, Executive Power, and the U.S. Constitution, was published in 2015 and was awarded the 2014 IIT Chicago-Kent College of Law / Roy C. Palmer Civil Liberties Prize. Kitrosser's articles have appeared in many venues, including the Supreme Court Review, the Georgetown Law Review, UCLA Law Review, and Minnesota Law Review, as well as a constitutional commentary. In 2017, she was awarded a Guggenheim Fellowship to begin work on a book project on U.S. government whistleblowers. Please give a round of applause for Professor Kitrosser. And I will now hand things off to my classmate, Dallas, to introduce our second speaker, and then we will begin the panel.
Good evening, everybody. I'm Dallas Kepler. I'm the president here of the Penn State Law Federalist Society. The Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to fostering balanced and open debate about the fundamental principles of freedom, federalism, separation of powers, and judicial restraint. The Federalist Society seeks to educate the legal community through its programs and publications about how limited constitutional government, based on the rule of law, can have a positive effect on law and public policy. Here at the law school, we do events such as like this tonight, panels. We also do solo speeches. We bring in various academics, legal scholars, and different people that's in practice. And but anyhow, tonight we have Professor Keith Whittington coming, and Professor Keith Whittington is the William Nelson Cromwell Professor of Politics in the Department of Politics at Princeton University. Professor Whittington received his bachelor's degree from the University of Texas, his master's of arts from the Yale in political science, his PhD in political science from Yale, where he graduated with distinction. He is the author of several books, among others is Repugnant Laws, Judicial Review of Acts of Congress from the Founding to the Present, which won the Thomas M. Cooley Book Prize, Constitutional Construction, Divided Powers and Constitutional Meaning, Constitutional Interpretation, Textual Meaning, Original Intent, and Judicial Review, among others. He has also published widely on American constitutional theory, development, federalism, judicial politics, and the presidency, along with numerous articles on impeachment, and including a forthcoming article in the Wake Forest Law Review on impeachment that will be published this year. He is also a member of the American Academy of Arts and Sciences. So let's give a warm welcome to Mr. Professor Keith Whittington. And with that, I would like to hand over things to Dean Osofsky.
Hello. Well, I want to join both Shifa and Dallas in welcoming all of you here tonight. It's really wonderful to have you here. And we're so delighted to have leading constitutional law experts, Professor Heidi Kitrosser and Professor Keith Whittington, to dialogue with us on a topic that literally I just can't figure out how it could be more timely. We did pick this date in advance. So, obviously the Senate began proceedings today. The House delivered things to the Senate yesterday. So this is clearly a very important moment to think about impeachment in this country right now. I also want to acknowledge that we're quite obviously at a moment of deep polarization in this country. And I think at this time, it's extremely important that universities play a key role, which is that of facilitating much needed civil discourse. And so I'm particularly delighted that the Federalist Society and the American Constitution Society collaborated to help us create that today. Right, to be able in here to have a thoughtful conversation about the topic of impeachment that goes well beyond kind of the sound bites and barbs that are going back and forth in our broader society. I want to just take a moment to thank the people at Penn State Law who've made this discourse possible. So, as I said, I really want to thank the student organizers, Shifa Abu Zaid of the American Constitution Society and Dallas Kephart of the Federalist Society for their leadership and collaboration in putting this event together. Let's just take a moment to acknowledge them. I also want to take a moment to acknowledge Professor Ben Johnson. You can wave, who's sitting right there. Yeah. So this really originated because he came to me and said, let's do something on impeachment. And there's this amazing speaker. And then it built into this entirely exciting collaboration between the Federalist Society and the American Constitution Society. So I just want to take a moment to really acknowledge Ben's sort of leadership around this event as well. So yeah, let's acknowledge Ben. Oh, I'm sorry, Professor Johnson. Yeah. And then I also just wanted to take a moment to acknowledge events like this take a lot of work from a lot of members of the staff team at Penn State Law. And so I really wanted to acknowledge our communications team, our IT team, Russ Schaefer and Randy Fulton, Lisa Rehart, Mary Beth Aber, and our custodial team that all came together to make this event possible. So let's acknowledge them as well. So the format that we're going to use tonight is obviously set up to be kind of an informal fireside chat kind of a format. What we're going to do is have each speaker make a few opening remarks. I think one of the things that's really wonderful about the combination of speakers we have is that Professor Whittington has a lot of deep expertise in the history of impeachment, and Professor Kitrosser has a lot of deep expertise in whistleblowing, which maybe has something to do with the conversation we're having about impeachment. So I think they'll pair really nicely. So they're going to make some opening remarks, then I will ask them a few questions, and then we'll spend most of our time in a Q&A with the audience because I really want it to be an interactive dialogue. So we'll turn to Professor Whittington first.
Great. So I first became interested in impeachment issues when I was a graduate student and beginning work on my dissertation in the early 1990s. And I had some particular theoretical reasons why I was interested in it at the time, but I thought it was one of those arcane topics that would never be particularly relevant. And so it's been very weird that I have spent far more time thinking about impeachment, talking about impeachment issues over the course of my professional career than I would have expected starting out. It's also a little striking how many new issues keep coming up on the issue of impeachment and new kinds of questions arising that are worth thinking about and often are hard questions. They're worth thinking about very carefully. So I know you're going to have a lot of questions. I want to get to those as soon as possible. So I just want to briefly make a couple points relating to how political the process is when we think about impeachment more generally. And of course, I would say that since I'm a political scientist, and so I have a stake in emphasizing how political these things are. But I think thinking about the politics of impeachment is particularly important. I want to note that in the context of sort of three different issues. One is the process. You should expect that the process is going to be highly political. It's obviously been highly political so far. I think not necessarily very high politics. I think we should expect more from our politics, from the version of the politics we've seen so far. But it's necessarily the case that the people who are going to be heavily engaged in carrying out the impeachment, both on the House side and ultimately on the Senate side, engaging in the trial, are worrying about the future of their political parties. They're worrying about their own individual political fortunes. They're worried about their own constituents and how their constituents are thinking about these things. And that's baked into the impeachment process as a whole. And so when you see people suggesting, for example, that some of the senators ought to recuse themselves because they are too interested and too partisan in the process, you should know that the senators are never going to recuse themselves. The senators will not require any of the other senators to recuse themselves because they all have political stakes here. They're all partisan, and we should understand the impeachment process as being coherent with that rather than somehow apart from that more generally. Secondly, in thinking about how political process is, I think it's also worth thinking about that the purpose of impeachments is primarily a political one. So Alan Dershowitz, since the very beginning of the Trump administration, has emphasized the idea that impeachment should only be used in the context of serious criminal offenses, things that you might be prosecuted for in an ordinary court of law. He is well outside the scholarly mainstream and thinking that that's true about the scope of the impeachment power. It certainly does not characterize how the impeachment power has been used across American history. For the most part, the impeachment power has not been used to deal with ordinary criminal offenses, but primarily political offenses. And more of the impeachment power is included in the U.S. Constitution precisely in order to deal with political offenses. The goal of having something in the Constitution that might, in particular, be used to remove a president before his term of office is up, is the possibility that a president might so severely abuse his power that you cannot wait until the next election before you remove that person from office in order to put those powers in a more trustworthy set of hands. It's obviously going to be a difficult political judgment to know when a particular individual has in fact abused their office such that that kind of remedy is justifiable. But that's the reason why we have an impeachment power in the Constitution in the first place. It's the reason why we should be thinking about using it, and it will require difficult political judgments to figure out when to use it. The third brief point I would make about sort of the political nature of the impeachment power is also that we ought to bear in mind, and certainly I think the House needs to be thinking currently about what the point is of impeaching a government official. And the most obvious point, obviously, is to try to remove an official. But we now have staring us in the face the fact that the House has impeached somebody that the Senate is very unlikely to remove at the end of that process, which raises real questions about why are we going through this if we don't think we're going to get the removal of the officer at the end of the process. And I think there are nonetheless some reasons why you would sometimes bring an impeachment forward, even if you don't think you're going to successfully remove the officer, because impeachments are tools that we've used across American history to do more than simply remove individual officers. We also use the impeachment power to emphasize our set of expectations about how officers ought to conduct themselves. We try to create lessons and build norms and enforce norms about proper scope of behavior of government officials in office. And so even if we think, for example, this particular officer, the President of the United States, may retain his office at the end of this process, nonetheless, the impeachment may be quite successful if part of what it does is set a set of expectations about how future presidents ought to conduct themselves, indeed how this president ought to conduct himself through the rest of his tenure of office, in order to exclude certain kinds of behaviors as being beyond the pale, not something you ought to engage in, even if it didn't necessarily result in the removal of this particular individual from office before the natural end of his term.
Great. Thank you, Professor Whittington. Professor Kitrosser?
Yes, thank you. Well, I'm so happy to be here, and thank you to Shifa and Dallas and Professor Johnson and Dean Osofsky. It's terrific to be here on this quite momentous day, not only because of this event here today. You know, as Dean Osofsky suggested, I come at this topic a little bit more peripherally than Keith does, in that I haven't written or researched in depth about impeachment per se, but I do have an expertise in government secrecy, and in that context have researched the topic of whistleblowing quite a bit, as well as particularly whistleblowing in the intelligence community, and also certainly the topic of executive privilege. So both of these things obviously figure quite importantly into impeachment, certainly into this impeachment, but a more fundamental way in which I do come to this, in which I come to this area, is also that in the course of looking at questions involving executive information control, I have studied the idea of executive accountability and presidential accountability in particular, and the kind of executive accountability that's contemplated by the Constitution. And obviously that sounds pretty heavily in the context. This is an important sort of part of the context in which we think about impeachment. So with all that in mind, I want to make just 3 quick points. So first, I want to say a word about the talking point that we've heard quite a lot throughout this process and even leading up to the formal beginning of the process, to the effect that impeachment would invalidate an election. This, in my view, this simply misunderstands the role of impeachment in the constitutional scheme and even the role of presidential accountability. First of all, as Professor Whittington discussed, impeachment, it's right there in the Constitution, right? The founders were well aware. It's even textually acknowledged that impeachment could include impeachment of a president. Obviously, the founders were aware that impeachment is something separate than elections, presumably would occur in between elections. But apart from the simple fact that the Constitution actually provides for impeachment, the more fundamental point is that much about the structure of the Constitution, as well as the history underlying Article 2, that is the provision that creates the presidency, assumes a type of presidential accountability that is pretty robust and that goes well beyond elections every 4 years. So for example, Alexander Hamilton, when extolling the virtues of having a single president as opposed to a council of presidential advisors, said in the Federalist Papers that a single president will be more narrowly watched and readily suspected. He also referred to the importance of the Senate confirming presidential nominees to executive offices in preventing executive officers from being people behind whom the president could hide his misdeeds. And so there are many ways in which structurally, and just looking at sort of the founding views about the way in which presidents would be kept in check, a lot of ways in which we see that the constitutional scheme contemplates a type of political as well as potentially legal accountability for presidents that goes well beyond a single election opportunity every 4 years. And of course, in the case, in the modern case, since presidents can now serve no more than 2 terms after the 22nd Amendment, many more avenues for accountability than a single re-election opportunity. And so in short, I think that the talking point that this would invalidate an election and it's somehow fundamentally incompatible with the Constitution really gives short shrift to the very rich and robust notion of accountability embedded in the impeachment provision in the Constitution, as well as other aspects of Article 2 and surrounding provisions. The second point I want to make is just to say a word about the whistleblowing process that really started, at least in the most immediate sense, started the impeachment process rolling. And I think this process shows us both the importance of whistleblowers in our system, and in particular the importance of having avenues for whistleblowing to take place, as well as the vulnerability of our system, particularly the system that the Ukraine whistleblower invoked, and the ease with which the system could kind of collapse or not work in any given case. So in this case, the Ukraine whistleblower acted in accordance with procedures provided by the intelligence community Whistleblower Protection Act. The Act's title is a little bit of a misnomer because it doesn't really provide generally for protections for whistleblowers throughout the intelligence community, but rather what it does provide is for a discrete set of mechanisms for people within the intelligence communities who spot what the statute calls a, quote, urgent concern, generally some sort of abuse of power or illegality, etc., regarding intelligence activities, provide some avenue for them to convey this information to the congressional intelligence committees. Under the Act, the whistleblower or the purported whistleblower is to convey their concerns to their agency or the intelligence community's inspector general. And then the Inspector General is tasked under the statute with deciding whether, in fact, the person has raised an urgent concern under the statute. And the statute says that if the IG, the Inspector General, spots an urgent concern or agrees there was an urgent concern, then the Inspector General, the language of the statute says that they shall then transmit that they then pass the information on to the Director of National Intelligence, but it specifies that the Director of National Intelligence shall transmit the information to the Congressional Intelligence Committees. And in this case, something unusual happened, which is that the Inspector General agreed there was an urgent concern raised, transmitted it to the acting DNI, Director of National Intelligence, and the DNI, and based on having seen the DNI's testimony, I think this was really all done in good faith. The DNI, I think, was concerned that perhaps maybe there's privileged material here. I'm not sure that I'm comfortable immediately transmitting it to the intelligence committees. And so he passed the complaint on not directly to the intelligence committees, but to the Justice Department, specifically to the Office of Legal Counsel in the Justice Department. They then wrote an opinion, interestingly, not saying that any of the material is privileged, et cetera, that there's some constitutional reason it can't go forward, but rather themselves interpreting the intelligence community Whistleblower Protection Act and applying it to the facts and saying, we don't think this does raise an urgent concern because we don't think it directly concerns intelligence activities, so we don't think you should transmit it to the congressional committees. In fact, the Inspector General was concerned about this, let the congressional intelligence committees know what was going on. The rest is sort of history. Eventually it leaked out to the press that there was a complaint that hadn't been forwarded to the committees, and eventually the complaint was transmitted, became public, etc. We see here, though, the importance of having some sort of avenue, and this is quite a discrete, organized process. This is not a free-for-all process. As you can see, there are a number of discrete steps for transmitting information of concern, for doing it in initially sort of closed, secure channels so that it can be done responsibly. At the same time, we see lots of potential avenues for failure, right? In this case, there were a lot of contingencies, a lot of ways in which the process, in which the complaint ultimately might never have made its way to the intelligence committees. If, for example, the Inspector General hadn't decided to let the intelligence committees know that it was held up in OLC. If we had a Republican control of the House, right, and that they hadn't made a lot of noise about this information being transmitted to them. Also, remember the fact that there was just a single whistleblower, right, at least initially. After, of course, this complaint came to light, we've had a lot of testimony from a lot of people expressing a lot of concerns, but it does pose an interesting counterfactual, right? What if this one person hadn't spoken out? So we see how vulnerable the system is. Last thing I'll say, and I'll just spend a minute on this so we can get to questions, and we could always talk more about this in Q&A. Just wanted to say a word about the way executive privilege factors into this whole process. And the part I'll focus on here is just to refer to the House's second article of impeachment, which is for obstruction of Congress. And essentially, the argument in this article is that the president is essentially refusing to cooperate or refused to cooperate with the House investigations. And what's interesting about the article is that it rests not really on a particular refusal, a particular response to a subpoena, for example, but rather the argument is, look, the president is essentially taking a blanket position that this entire thing is invalid, and therefore we're not going to cooperate as a matter of principle. So that's the basis on which the article rests. And I think, my own view is I think this is actually quite a sound basis. There absolutely is, under the case law precedent, regardless of what you think of the case law, the reality is under the case law, the president absolutely does have a basis to make claims of executive privilege. At the same time, the case law is quite clear that broad blanket claims, not based on specific concerns about specific items of information, etc., are unlikely to prevail. Certainly true for broad claims of testimonial immunity from given individuals even having to show up in the first place. So my own view is that this second article, even though I think it's somewhat controversial, is pretty well founded. But obviously, executive privilege also factors in other ways, including questions of what will happen if the Senate does call for witnesses and they simply refuse to appear, etc. But I'll leave it at that and look forward to the conversation.
Terrific. Well, one of the things that is interesting, if you think about the confluence of your two remarks, right? So you're talking about the politics of the process, and you're talking about the process of information coming through. And of course, one thing that's been very complicated in this impeachment process is the interaction between politics and information. And even since the House vote, there's been new information coming out. And so I'd be interested in hearing both of your perspective on sort of the appropriate way for this kind of process to deal with a situation where there's unfolding information. This is obviously not unique to this situation, where you're learning more as the process is going on.
Well, I'll just start it out. It is really fascinating, right, to see this all playing out in real time. And as the dean says, it's not unusual in theory, but as the degree of it, I think, is sort of unusual. I mean, it's just like an avalanche of stuff constantly coming out, including on Monday night before the impeachment articles were formally transmitted to the Senate. Just a couple thoughts. So one kind of practical and one more theoretical. So the practical thought is that this presents both opportunities and great challenges, right, in terms of moving proceedings forward. Opportunities, just taking the perspective of the Democrats, right? If you're a Democrat, if you're one of the House managers, or one of the impeachment managers in the Senate trial, politically, talking about the intersection between politics and information here, politically it presents some opportunities, right? Maybe opens up avenues for further public pressure on moderate Republican senators, right? To say, oh my God, look, there's all this new stuff. Lev Parnas talked to Rachel Maddow, and all of these new documents were released by the House Intelligence Committee Monday night. Surely, the Senate at least wants to look at this stuff, right? So it sort of opens up avenues for public pressure. Obviously, though, creates more challenges, right? What do you do when the executive simply refuses to cooperate? The House took the view that it would take too long if we contested the subpoenas, took it to the courts, waited for resolution, and so they proceeded essentially without, calling witnesses who refused to comply with testimony. So how will that proceed? Presents new challenges. As a theoretical matter, I'll just make the observation that it's really fascinating to think about the way information cascades are working here, right? So I mentioned the whistleblower. That was an example of one person making this complaint, could have easily never been made, or maybe could have been bottled up, right, after OLC stepped in and rendered their opinion. Once it came out, though, it was sort of like opening Pandora's box. I mean, that then led to other people, other documents coming out, ultimately led to the impeachment proceedings, led to witnesses, etc. And so it'll be interesting to see. I suspect we'll have similar dynamics here, where some information comes out, maybe that does cause pressure, that leads to more discovery, possibly more pressure for witnesses, may lead to more disclosures, may lead to more leaks to the press, etc. So it's a very dynamic cycle.
Yeah, I think the second article of impeachment is an important aspect of this issue about the additional information coming forward. I mean, one reason why, of course, additional information is coming forward is this is a complicated event. It occurred mostly in secret. You would expect that the investigation might take quite some time, including that information is going to trickle out to some degree, which poses challenges for the House in thinking about whether or not to pursue impeachment at all, given how late in the term the scandal itself broke, and then how much time do you actually have to conduct a thorough investigation. I think it's perfectly reasonable for the House to make a calculation that there's information we don't know yet, but we know enough to be able to move forward on the substantive charge contained in Article 1. At the same time, Article 2 emphasizes the fact that the executive branch, by being so non-cooperative, is guaranteeing that information is not going to be readily available to assess the first component. The administration is the one that's responsible in part for the fact that information will continue to trickle out gradually over time. And it's not unreasonable, I think, for the House then to say that it's the administration's fault that this process is giving rise to this awkward situation in which you're having more information coming out. I think, again, on the political front, it raises interesting questions, I think, in particular now for Republican senators who all along have been, it's also true for Republicans in the House, but I think Republican senators in particular have been in this awkward situation that all along they are expected to defend the president. They're expected by their own constituents and voters to defend the Republican president in this context, but they don't know what the story is. They don't know exactly what it is they're defending. And so as a consequence, and the administration's own argument about what happened and what the rationale and justification for what happened has changed over time. And so I think Republican politicians find themselves in this awkward situation where they're sometimes having to offer public defenses that they will soon have to walk back. Because new information will become available that will suggest, well, that defense isn't going to hold up. We have to move to some other defense in the future. I think now Republican senators are going to have to be in a situation where they're going to have to think about the fact that new information will continue to come to light, including information that's going to come to light after the trial is done. And after they've cast their votes on whether or not to acquit and convict. And almost certainly all the additional information that's going to come to light is going to look bad for the president. And so to what degree do you want to be a senator voting to acquit when you know that there will be additional shoes that are going to be dropping after you've cast that vote that will make your vote look increasingly bad over time? It may still be justifiable to vote to acquit under those circumstances, but they need to think carefully about what kinds of arguments they're going to construct, knowing that there's going to be more information that's going to come out down the road.
Actually, if I could just add one thing, it reminded me as you were speaking that, just another thing that came out just today, and because I was being driven around to places like the Creamery, I wasn't able to look at it in depth, but I did take a quick glance and saw, the Creamery is great, by the way. I just took a quick glance at the news and saw that the Government Accountability Office today released a report concluding, a 9-page report concluding that that the OMB, the Office of Management and Budget, which sort of technically was the office in the executive branch that sort of technically held up the funds that had been appropriated by Congress for Ukraine, that they acted in violation of their legal directive. But the part that's, and so obviously that's yet another revelation, but the part that struck me the most about it, just from skimming through it without having had a chance to read the whole thing yet, is the fact that toward the end of the report, the GAO, essentially for the GAO, pretty inflammatory language, said something to the effect that, the administration did not cooperate in turning over information. We still haven't been able to fully do our job in the way that the law demands. Because this information has not been turned over. And they said something, they even had some very strong paragraph or sentence that said something to the effect of, the failure to turn over the information has constitutional implications. So that adds yet a little more gloss to all of this.
So one of the things that's very clear in that the answers you're giving, and I particularly noted when you said the Senate Republicans, well, the House ones too, but especially the Senate Republicans, right, is that one key aspect of the dynamics that are going on in these impeachment proceedings is that Article 1 of the U.S. Constitution divides the process between the House and the Senate. And so, in a situation like we have right now, where the House and the Senate have different partisan compositions, right, that is real implications. And so I'd be interested in your reflections of what you see as the key benefits and limitations of the division of power within Congress in both this historical context that you've studied a lot and also the current one that we're looking at today as well.
Yeah, it's an interesting question. I mean, I think there's one feature of the impeachment power, of course, is that it is hard to remove somebody like a president, right? It requires a lot of support within Congress and really within the general public in order to remove a president as a whole. And this two-stage process by which you need bicameral support ultimately to remove president is part of that. Ultimately, in order to convict, you need supermajority support within the Senate, which makes it even more difficult. The founders, I don't think, clearly did not anticipate the ways in which political parties would grow up and the consequences that would have for how a process like this would work, as well as other features of our constitutional system more generally. And that creates real problems. So, for example, there were occasions during Andrew Jackson's presidency in which the Whigs very much thought that Andrew Jackson ought to be impeached and indeed removed from office. And their problem, from their perspective, was they did not have a majority in the House of Representatives, so they couldn't even launch an impeachment process because the Democrats controlled the majority in the House, and Andrew Jackson could rest secure in the fact that he knew that he would not be impeached. And as a consequence, Jackson would frequently issue messages saying, well, if you really don't like it, impeach me. And of course, knowing that his party controlled the majority in the House and they would never impeach him in those consequences, which made the Whigs who were in the Senate, who actually had a majority in the Senate, very unhappy because they were anxious to get impeachment articles into the Senate. And one feature of this process is the Senate can't launch its own impeachment process, right? It needs the House to launch that impeachment process in the first place. So it's very hard to move this process forward. It's designed to be hard, but with the nature of political parties, it certainly complicates it. In some ways, makes it easier. The Democrats are particularly enthusiastic about impeaching the current president, but in some ways also makes it hard. Republicans are particularly dug in protecting this particular president.
Yeah, I would largely echo that. I suppose all I would add, mainly just an elaboration on that point, is that it is striking to think about the sort of divergence between the theory behind, why it is. I mean, obviously, like with all things in the constitutional text and history, there isn't one monolithic theory or rationale for particular provisions, but to the extent you can sort of glean from the text itself and from the history a theory as to why we divide the power in the way that we do between the House and the Senate, the divergence between that theory and the practice, largely because of the gloss that parties add to it, it really is striking, right? I think the theory is partly, as Keith said, simply to make it hard, right? In the way that bicameralism makes even passing legislation hard. Obviously, this is an even weightier task. Also, in the way that it, I think, does envision somewhat distinct roles for the House and the Senate, it being a little bit easier to impeach, sort of the equivalent of indicting, and, kind of perceiving more of kind of a roving investigative process in the House, as opposed to perhaps the more measured trial, perhaps somewhat more legalistic, contemplated trial in the Senate, the harder threshold to get a conviction. But compare that sort of theoretical divide and the theory of the respective roles with the reality, which is just so inextricable from the existence of parties, right? So if we look at the current impeachment proceedings, it's not clear that there's, a marked difference in the contemplated procedures in the House and the Senate, so much as there is a stark difference simply based on party alignment, right? A stark and very predictable difference, so that the main difference between the House and the Senate in this case being, one is Democratic, one is Republican. It is great to get the historical perspective from Keith, right? Recognizing that this is not a new phenomenon. At the same time, I think arguably it's become an even more intractable phenomenon. I keep thinking about this Law Review article from 2006 by Darrell Levinson and Richard Pildes called Separation of Parties, Not Powers, where they talked about how the Madisonian model, the separated powers, was based on this idea that Congress people would be loyal to their institution and protect the sanctity of their institution. Same thing for executive branch officers, same thing for judicial officers. Instead, what's happened is that everyone's clinging to party-based loyalty, and that really does, cause sort of a breakdown in the separation of powers.
The one qualification I think that it's worth noting in the impeachment context is the vast majority of our impeachments at the federal level have involved lower court judges. And these are not primarily partisan affairs. And so the kind of expectation about how the impeachment process works does play out much more naturally in the context of some trial court judge being accused of corruption who won't resign from office, and as a consequence you go through the impeachment process. Presidential impeachments in that sense are different than normal impeachments, and as a consequence I think put a much greater pressure on the way the constitutional system works, emphasizes this partisan aspect of how the process works in ways that's going to be less true in other kinds of contexts.
So these answers and the comments you've been making throughout really lead to my next question, which is about procedure, right? So clearly, as both of you have alluded, a key dispute point is what process is going to be followed in the Senate trial. And particularly, the dispute is particularly locused around how witnesses are going to be handled. And so I was really interested in hearing your perspectives, both sort of from historically, from past impeachment trials, not just of presidents but of public officials. How are witnesses typically used, and also kind of based on your analysis of kind of how whistleblower processes emerge into broader information processes. What does that imply for how witnesses should or shouldn't be used in this context?
So it's notable, right, that the way the impeachment process is structured, the Constitution refers to a trial in the Senate. There's expectation, and there's something that's going to be trial-like in the Senate. But the Constitution is not very specific about what that trial-like practice is going to look like, and it's varied a lot over the course of American history as to what exactly Senate impeachment trials look like. And some of that variation is a function of the particular kinds of charges being brought and the particular context in which they're being brought. Some of it's just changes in the nature of Senate practices over time, especially given some of the current talking points that have come up recently. It certainly is worth emphasizing that historically, when the Senate holds impeachment trials, it tends to hear actual witnesses and take testimony. It tends not to simply rely on what the House itself had done as part of the House impeachment inquiry. The Senate will talk to witnesses and collect evidence and enter into the record evidence that was not part of what the House had done in its initial inquiry. There's an expectation that there will be two sides battling it out in front of the Senate, and they will both be bringing forward the evidence that they think is going to be helpful for their particular side. At the same time, it is also true, and especially in the context of a presidential impeachment, that the Senate as a whole, senators and the senators of the two parties, are also trying to think about what the political implications of this process are going to be. They thought about that when they were impeaching President Andrew Johnson. They thought about that when they were impeaching President Bill Clinton. They're trying to think about how is this going to play with the public? How is this going to have consequences for the future of the political party in the next presidential election? And so as a consequence, they're thinking about how to cabin that process so that it isn't detrimental to their interests as they perceive them going forward, as well as thinking about what are the immediate consequences for this particular incumbent who's being put on trial at this particular moment.
Yeah, so just a few things. One is that it's so interesting to think about the way we talk about precedents when we talk about impeachment, and this gets back to Keith's foundational point that this is an intrinsically political process, right? So normally when I talk to law students about precedents, right, more often than not we're talking about judicial precedents. This is an area where we draw overwhelmingly on precedents in past impeachment proceedings, right, in the political branches. And certainly when it comes to presidential impeachments, we have such, just a shallow set of examples, a small set of examples to draw on. But this is an area where I think it is really, really useful, in part for trying, to the extent we possibly can today, to get past the purely partisan calculations to actually point to past precedents in order to point, for example, to, as Keith was saying, the just routine nature of calling upon witnesses, of discovering new evidence in the Senate trial part of impeachment proceedings. So it's at minimum a very useful starting point. Ideally, in terms of moving forward with procedures and trying to sort of break out of the logjam of each side thinking only about sort of immediate partisan interests, ideally, in an ideal world, one would want to try to find some sort of bipartisan agreement on procedures. Now, people often point to the example of the Clinton impeachment, where the Senate actually did, the minority and majority leader actually did manage to broker, a widely accepted agreement as to the procedures that they would follow. I don't think we're going to get to that point here, but I think instead sort of the closest that we can come here is the bringing in of perhaps a few wavering Republican senators who everyone seems to be looking to see if we can get some agreement from them that they would be on board with becoming part of a majority to agree to procedures whereby we have witnesses, etc. Also, on the point that Dean Osofsky raised about bringing in new information and how that can sort of relate to the process of witnesses. It is very tricky because, like in any trial, information gathering, discovery, information disclosure, of course it's very important. At the same time, there are rules of evidence in ordinary criminal trials to ensure, perhaps more than anything else, that the information be relevant, right? And so that comes into play when we start getting into arguments, for example, about, some of, I think Mitch McConnell and some others have said, well, if you want witnesses, then let's call Hunter Biden, let's call Joe Biden, etc. And that's where I think we may get into some sticky questions into which Chief Justice Roberts may find himself getting, called upon perhaps to rule on relevance. Of course, a majority of senators could overrule relevance determinations by the Chief Justice, but I think that may be an area where if they do end up agreeing, if they get a majority to agree to hear witnesses or to receive new evidence, that could be where the rubber really meets the road in terms of difficult questions of how will this actually play out in practice.
Although it's worth noting that the Senate's own precedents hold that the federal rules of evidence don't apply in Senate impeachment trials.
Right.
So it's a unique body of rules about what rules of evidence apply, and it doesn't look like an ordinary court in that sense. And so it becomes a very open question as to whether or not, how wide are you willing to cast the net in allowing these things to proceed? Yeah,
no, that's absolutely right. And just to clarify, that's obviously that's not to suggest that the federal rule of evidence itself would apply, but presumably, the question would be, brought to the Chief Justice and raised to fellow senators, as you say, in this context, given that we have so much leeway to craft and apply procedures for ourselves. How narrowly or broadly do we want to define what's relevant? How will we make these decisions, etc.?
So one last question before we open it up, because I really do want to leave a lot of time for audience participation. As has been clear in all of the answers you've been given, and particularly this final interchange, part of what makes the current process so complex is the deep level of polarization in this country. Are there any strategies, whether historical or other ones, that you think would be most helpful in decreasing partisanship and establishing a good process?
I am not optimistic about decreasing partisanship or establishing a good process. I think the process has been a mess so far. I was very disappointed about how the House has pursued the impeachment process on the whole. I don't think it's very well handled, either from a purely constitutional perspective or from a political perspective in terms of trying to build support for the enterprise more generally. I have no real expectation that the Senate trial is going to be very pretty. I expect it will also be a clown show. And as a consequence, I think we will wind up coming out of that process very dissatisfied with what it looks like at the end of the day. And certainly I think the impeachment itself and the impeachment process is not going to be the moment in which we're going to overcome partisanship. I mean, I think there is a challenge moving forward about how to think about overcoming partisanship in various ways in our political system generally and in Congress more specifically. But a presidential impeachment is probably not the opportune time by which we're going to come to that particular miraculous conclusion.
Yeah, I am similarly somewhat not terribly sanguine about this being a moment where we'll triumph over partisanship. I think in terms of kind of immediate sort of procedural approaches by members of the Senate themselves to try to overcome it, I think probably what I suggested earlier in terms of trying to refer back to earlier procedures, trying to sort of transcend just the facts of the moment in appealing to other senators and appealing to the public, might be a starting point. I think ultimately, as I said before, the best hope of bipartisanship is not some sort of broad crossing of the aisle, but perhaps bipartisanship, in the sense of some agreement between the Democrats and a handful of potentially wavering senators. I also think, we can't get away from, in terms of how difficult it is right now to transcend partisanship, we can't get away from the media environment. I mean, more so even than in the Clinton impeachment and certainly in earlier presidential impeachments, and certainly more so than in Clinton, we have a media environment right now where, different partisan compositions, different pieces of the country that have sort of aligned themselves based on partisan affiliation have essentially very different factual starting points, right? People are getting very different understandings, oftentimes depending on what media they watch, they listen to. And so that's, just I think another challenge in terms of reaching any sort of shared agreement, at least as to basic facts, as well as to what the various motivations of the parties are.
Yeah, absolutely. Part of my preparation for this evening was to watch the coverage on both MSNBC and Fox News, and let's just say they weren't identical. On that happy note, I want to open it up to audience participation. Because this is being live streamed and we want people listening to be able to hear, and people in the auditorium to be able to hear, I'm going to ask people who have questions to come forward to the two microphones in the aisles. And I also just want to encourage, in the spirit of civil discourse, that people focus on, and to allow maximum participation, that people focus on questions rather than lengthy statements.
My question is...
And can you identify yourself?
Oh, yeah. My name is Joe Malizia. I'm a local attorney, one here, graduated in 2011 from this law school. Am I being recorded? Good?
Yes.
Yeah.
Okay. My question is whether impeachment, is it inherently political versus criminal, that dichotomy, is that in fact, especially from a historical perspective, a false dichotomy? And what I mean by that is, in the criminal context, I know you don't want to like this statement, but just to clarify what I mean here, in our modern day legal positivism mindset, we think of crimes in terms of exactly that specific elements, but back in the day, it was when the founders in 1787 made the Constitution, that was not the legal philosophy that predominated the day. It was theories of natural law. Additionally, just to anchor what I mean here for someone who doesn't have like a political philosophy background, George Washington once court-martialed individual for a violation of their oath. I believe it was an oath of enlistment, something that sounds just wild and crazy. So back to the original question, is a criminal versus political, when we hear political, we think elections, criminal, we think that legal positivism, is that really even is that a false dichotomy? And is that something that does not translate to a 21st century audience?
So So I think it's an interesting question, right? I mean, there are reasonable analogies to be drawn between the impeachment process and a criminal process. I just don't think we want to get carried away with thinking about how well the analogies apply in these contexts. So, for example, there is an expectation that the House brings forward articles of impeachment that are sufficiently specific and clear that it's possible for a defense to make an argument about whether or not that you've met them, right? They frequently get referred to in that context as being similar to a bill of indictment, and that they need to have the right kinds of particulars such that you can actually gain some leverage in them in a trial. And it's a mistake if the House can't structure their charges in a way that creates an opportunity for the defense to make arguments against them. On the other hand, there are other places where the analogy becomes more difficult. So, for example, in the Andrew Johnson impeachment, one of his members of his defense team wanted to argue in particular that it was inappropriate to charge the president with these particular offenses because it was not clear they were in fact offenses going into the process. Effectively, the House was creating ex post facto laws and retrospectively applying a new standard as to what presidents could be held to account for, that Johnson would not have had an adequate prior warning going into the process. Al Dershowitz has echoed some of these kinds of arguments more recently, for example. And the House rejected that argument. Most of the senators rejected that argument ultimately, in part claiming that that's perfectly reasonable in the context of a criminal trial where somebody's life or liberty is on the line, not so appropriate in the context of impeachment where the only thing at stake is whether or not you continue to hold office, and as a consequence we want relatively flexible standards in thinking about abuse of powers that may be more flexible, more fluid, and may not be clearly defined until we actually have the occasion to be thinking about in that kind of specific context. So I think there are places where these two things tend to come together fairly well, but there are also places where they really clearly tease apart, and our expectations become pretty different about how, and historically at least, I mean, and like I said, of course, there are people inside any of an impeachment event who want to sometimes push them further apart, and others have an incentive to pull them closer together. But I think traditionally there are just some important distinctions between how the impeachment process is tended to work and how we think it ought to work, and how we expect a criminal process to work.
Yeah, I would just echo the point that, yeah, it is a useful analogy to a point, right? It can be sort of counterproductive if taken too far. A good example of the latter is, I think, that the tendency, and Keith associated this with Alan Dershowitz, for example, though others have said it too. A good example is the fixation, which I think is a pretty anachronistic one, among other things, by some of the president's defenders on the idea that, there has to be a crime, which is just incompatible, with the historical understanding or the historical practice, or even the logic, right, of what impeachment is about. On the other hand, it is useful. I mentioned the idea, for example, of arguments about what evidence should come in. It's sort of useful, although obviously we're not bound by the federal rules of evidence here. It is sort of useful, perhaps, to hearken in deciding what should come in, what shouldn't come in, to the idea of relevance. Also sort of useful to, draw an analogy to the indictment process and then the trial process, etc. One other thought that this calls to mind is not just the dichotomy or the relationship between politics and criminal law, but the relationship more broadly in these proceedings between politics and law more generally. Because while I was thinking about this when Keith was first talking about impeachment as a political process, one of the things that's interesting about it is that it is, in all the ways that he suggested, I think it absolutely is a political process, and particularly in that it's one that is essentially resolved and ultimately, the decisions made are up to the two houses of Congress. This political branch. But it's this interesting interplay of politics and constitutional law in that part of what's being played out and argued about on the part of each house is what is the meaning of these constitutional terms, most notably what is a high crime or misdemeanor. And I think that we see that interplay whenever we see a case where, a branch is given constitutional responsibility to do something in a way that doesn't really lend itself to judicial review. And so the process is necessarily political in that, the political branch gets the final decision, and yet there is an element of constitutional argument being made both within members of the branch to one another, as well as back and forth to the public, right? In arguing, again, in this example, what is a high crime or misdemeanor?
Thank you.
So I think you were next.
Hi, my name's Sarah. I'm a current law student here. My question goes to the legality of the amount of time that Nancy Pelosi withheld the articles of impeachment for the Senate before she transferred them to the Senate, and has that historically done before, and what kind of precedent does that, I guess, establish for possibly future impeachment hearings?
So it's not unprecedented, and I don't think it will have big consequences for future impeachments. I'm not a big fan of how this was done, but it's worth noting that given the timing of when the initial articles were voted on in the House, it was probably always going to be the case that they were not going to be delivered to the Senate until after the holidays. And so the thing I don't like very much about this is that Pelosi made a big show of the fact that she was not going to, and then teased us about how long she was willing to wait. I think the actual gap that has in fact occurred is probably the exact gap we would have expected if there had been no public conversation about holding them, particularly. But it's worth noting that this process has also varied over time as to what it looks like. Some of it is actually variation that has created patterns over time, but some of it's sort of idiosyncratic in particular instances. So, for example, there have been impeachments in the past in which the House has simply announced and resolved that an official is impeached. They then go to the Senate and tell them, we have impeached so-and-so for high crimes and misdemeanors. We will send you articles later when we figure it out. And then they go back and they debate about it, sometimes for months, before they figure out what the actual articles of impeachment are, and then they bring them forward. So everyone knew that you needed actual articles before you could have a trial, because you needed a specific accusation that somebody could defend themselves against in order to actually have the trial and decide whether or not to convict. But the decision that you think that you want to lodge the accusation could occur pretty quickly and easily, and the House in the past has been willing to make that accusation before they ever have any sense about what exactly the articles are going to wind up looking like. And the very earliest impeachment episodes had very extended gaps between when the House initially notified the Senate, we hereby impeach somebody, and when they actually showed up with articles of impeachment and said, okay, now we're ready for a trial to go forward. And so I think from a broad historical perspective, then there's nothing either wrong or unusual about the House being slow about this, and I don't think this will have consequences going forward. But it did give rise to this very interesting question about when exactly somebody's impeached, which I've participated some in this debate, and it turns out it actually is a little complicated as to know when is the moment exactly when somebody's actually been impeached, and I think actually the answer is not entirely clear, but probably we have a different answer that we conventionally come to now than when the early generations actually would have understood that moment to have occurred.
So, for what it's worth, I was not particularly troubled by the delay, to the extent there really was a delay, because Keith's point is well taken about the holidays, but certainly Nancy Pelosi, sort of framed it as a delay. I wasn't troubled by this, in part because I think this is sort of a perfect example of the appropriate use of sort of politics in the sense here of both public appeals and appeals to Mitch McConnell and others in the Senate, in terms of mostly what the process would look like. So to the extent that, Mitch McConnell had made public statements about, his position being clear and working in tandem with the White House, I think it was an appropriate and probably fairly savvy move to do this, not necessarily to gain anything tangible, but to highlight for the public, to kind of take a pause and do a freeze frame and sort of highlight for the public, look, we're concerned about the process that's going to take place in the Senate. We think it's important that there be witnesses. We think it's important that the process be as impartial as possible. Pelosi certainly didn't have a whole lot of cards to play at that point. It's largely in the Senate's hands at this point. But I think doing a little freeze frame and announcing that that was her reason for the freeze frame might have been the most effective way she could to sort of shine a spotlight on these procedural concerns and bring public attention to it, and possibly also put some more pressure on moderate, potentially wavering senators on that score. She might have also been gambling that more information was going to come out, in part because the House Intelligence Committee themselves released more information on Monday night. That might have been part of her thinking. But I think even apart from that, it was I think, a reasonable approach.
Professors, thank you guys for both coming out, and I appreciate your time. I'm Eric Greiner. I'm a 3L here. And I guess my question really has to do with, we talked a lot about horizontal separation of powers, parties, politics, and playing in kind of the administration. My question is, obviously with the changing of the 17th Amendment and the Senate, they're directly answerable, almost as the House is to the people. Versus, I know, Professor, you mentioned that the Senate's supposed to be more deliberative, more time-based, and a lot of the Federalist Papers say, they're supposed to be more representing the interests of the state. So, in the context of the Trump administration specifically, immigration and things of that nature, and all the changes in the regulatory regimes, I guess the question I have is, where do states' interests lie in impeachment? In this case and in going forward, as far as how are they supposed to be represented in these issues? I think there's kind of a glaring vertical Federalist gap here that has kind of obliterated a lot of Madisonian structure here. I wonder if you could speak to that.
That is a really interesting question. So I guess my off-the-cuff thought is that usually it would depend, obviously, on the specific issues at stake in a given impeachment, the specific articles and facts. I would usually tend to think of impeachment as something that would involve issues that would probably transcend issues that break down in obvious ways, at least along state lines, that obviously have differences in terms of how states materially will be affected. That said, at least in the present day, certainly, I think that that there is effectively a breakdown between, just simply in terms of partisan affiliation, right, between states. And so, in a sense, I think to the extent that we could identify, quote unquote, state interests, I think there's a lot of overlap, if not complete overlap, between those interests and the kind of partisan interests and partisan affiliations that we referred to. So, and in that sense, to the extent that the Senate might map on somewhat differently, right, in terms of reflecting kind of the partisan composition of states as a whole, as opposed to individual districts, that's having more variation within states like you have in the House. That might be, some difference from the House. But yeah, I'm not sure there is, in this case, identifiable state interests, at least that are clearly and obviously in play beyond the partisan compositions of states.
Yeah, one question is how important you think that ought to be within this kind of context of thinking about impeachment. So if we thought that states qua states should be or were conceptualized as playing an important role in the impeachment process, one way of imagining that is imagine instead of the Senate being the place where you have an impeachment trial, instead you had a body composed of state governors who served as the jury for or judges for an impeachment trial. And it's not all clear, I think, that the framers were thinking in those terms. The senators were representatives of the states in this context. I think instead the conception is much more along the lines of thinking that the Senate, as was traditionally true in the context of the British Parliament, as was also true in the context of the states, which already had impeachment mechanisms that worked on this kind of bicameral structure. The Senate was a smaller, more judicious, more mature body, people serving generally longer terms of office, often older politicians, more experienced and the like. and the expectation then that they were particularly judicious. And that was a valuable thing for this purpose of sitting an impeachment trial, rather than thinking they're the ambassadors of the states. And that's the constitutional salient feature of the Senate that's playing a role in this context. It's also worth noting that despite the fact that senators at one point, of course, were chosen by state legislatures rather than being elected, they were still deeply partisan in the world in which they were chosen by state legislators, and that had real consequences for things like presidential impeachments, for example. And so in that sense, they're not so different. I think part of what we have in fact lost, though, in this context, in a modern context compared to earlier contexts, is not necessarily the senators are much more partisan than they used to be. They were very partisan in the 19th century compared to now, is that what is less salient than what once was the case was the 6-year term. That it once was the case that senators were relatively insulated from immediate political pressures, and that clearly is not true to the same degree now. Senators feel themselves being very vulnerable, constantly running for re-election. There's not a strong sense of, I don't have to worry about this for another 4 years, and so I can vote relatively independently. They're a lot like House members in that sense of constantly looking over their shoulder at the electorate. And that's a real change, I think, compared to earlier points in American history where there was less of that. I think the other thing, though, that's relevant and has a hook to what you mentioned is this question that I mentioned early on of should senators recuse themselves because they have conflicts of interest and the like. This has come up at various points in various Senate trials. It came up during the Johnson impeachment, for example. So President Andrew Johnson's brother-in-law was a senator from Tennessee. There was a suggestion that he ought to recuse himself from the impeachment trial of Andrew Johnson. Senator Benjamin Wade was the president pro tem at a time in which there was no vice president of the United States, and as a consequence, he was next in line of succession if President Johnson had been convicted and removed. So there was a suggestion that Wade should recuse himself from the Senate trial, and both of them refused to do so, and the Senate as a whole refused to make them do so. And the argument that was offered was the people of my state deserve to be represented in this trial. And as a consequence, I have a political obligation as a representative of my state to participate in this trial. It would be inappropriate and a slight to the citizens of Tennessee if Andrew Johnson's son-in-law didn't participate. And so I think that's still a salient question, right? So if you think about should Marco Rubio or Elizabeth Warren or Lindsey Graham, various other senators who've said lots of public things about how they think about the impeachment process, should they recuse themselves from the process? I think that argument still holds to say the people of my state deserve to have a vote in this important process, and I'm the person who has the vote, and so as a consequence, I have to participate. And in that sense, I think there is still a real salience to this, but it's a connection not to state governments per se, but to the people of the state, the sovereign states as such.
Hi, my name is Masuma. I'm an LLM student. So my question is with regard to the ongoing conflict with Iran. My question is, do you think that the ongoing tension with Iran has somehow overshadowed the Trump impeachment, or is it going to delay or affect Trump impeachment in some sense?
Can I just ask you, I just got a signal from the back. Can you move a little closer to the microphone and then say it one more time so the people at the back can hear?
So my question is with regard to the ongoing conflict with Iran. Do you think that the ongoing tension with Iran has somehow overshadowed Trump impeachment, or if it continues, is it going to affect Trump impeachment or delay at least to some extent or not?
Yeah, well, initially, I mean, time will tell. We'll see how things develop further with Iran. But initially, after the Soleimani strike, it did seem to me that this, took attention off of impeachment for a few days. And I think, and there was a point where obviously, it was very uncertain whether something in the Middle East, it was going to become very chaotic and violent very, very quickly, and everyone was kind of holding their breath. Once we reached a point, and hopefully this isn't just a false sense of security, but once we reached a point where it appeared that maybe things were cooling a little bit, It did feel, I mean, this is just from kind of a, putting on a pundit hat perspective, it felt like things were getting back to where they were a few weeks ago in terms of focus on impeachment. If things were to heat up again, sure, as to whether there'd be a formal delay, we'd see how that would play itself out. It's unfortunate, but I don't know that any of the players could really separate themselves or can really be expected to separate themselves from partisan calculations in terms of whether it's in their party's interest to say, oh, we better hold off on this, or whether it's in their party's interest to say, let's just get through this really quickly because we have to rally around the country. So I think it's unclear. In the moment, though, if things remain, with the sense, whether it's a false sense of security or not, like we're in a bit of a cool down period, then I think it probably won't affect things beyond how it did initially.
I think that's probably right, that it probably, at least right now, doesn't look like it's going to have a significant effect one way or another. But I think there are two things associated with that kind of conflict that are potentially quite significant to an impeachment context more generally. So one, you can imagine there being real national security or geostrategic concerns about impeaching your commander-in-chief in the middle of foreign policy crises more generally. So you can imagine it puts a bit of a damper, for example, on the possibility of using the impeachment power against the president in the midst of the Cold War, where part of what you have to worry about if you're a member of Congress is, if we're pursuing an impeachment, what's that going to do about Americans' posture relative to the Soviet Union, and is it going to put us in a position where we're going to be more vulnerable to some kind of Soviet aggressiveness, for example, because we are in the midst of this internal crisis. And you can imagine congressmen thinking, we're going to have to suck it up and tolerate some presidential behavior that might in other contexts be impeachable, but we're not going to do that in the midst of the Cold War. And you can imagine some similar kind of calculation occurring in this context as well, where you might say, look, there are going to be real ramifications from a foreign policy perspective to move forward with this, and so as a consequence, we need to backburner it. It doesn't look like we're in that situation, but you can imagine that kind of thing playing out. The other thing, though, I think is also interesting about the Iranian situation at first, which is traditionally, when there are big military moments, there's a rally around the flag effect from a public opinion perspective for presidents. Presidents tend to get a public opinion bump from attacks on the United States and other kinds of immediate military conflicts. Trump didn't get one, right? So, but you can imagine a situation in which there's some kind of military strike, there's some kind of serious foreign policy conflict, and suddenly the president's much more popular with the general public as a consequence of that. It's relatively short-lived. These things don't last for a long time. But if you're in the midst of an impeachment trial, when that moment happens, you can imagine a lot of senators saying, well, I'm not going to impeach this guy who now has high public, even higher public approval because of what just happened internationally. Part of what's interesting about Trump is nothing affects him. So from a public perspective, yeah. Nobody who likes him is going to dislike him, and no one who doesn't like him is going to come to rally around him, no matter what happens, apparently. And so as a consequence, he didn't get that kind of bump. And as a consequence, I don't think it would have had the consequences you might have expected it would have in the context of an impeachment and the politics surrounding an impeachment.
Just a couple of elaborations on that real quickly. That calls to mind, I think the week after the strike or something, a poll came out, maybe it was USA Today, showing that, I think it was, I forget the exact number, but a majority of Americans thought that the Soleimani strike made the U.S. less safe, which was a really striking result. Now, maybe we could just attribute it to the fact that the numbers are always the same with Trump, right, no matter what happens. So maybe it's just that, just mirroring kind of the normal approval-disapproval ratings. But it does call to mind whether, as Keith suggests, whether the rally around the flag and rally around the president effect would be different. And in that respect, one other thing I'd say is, I think Keith is exactly right descriptively that the rally around the president effect, that would be the classic one in an impeachment situation, would be for people to say, look, we really have to kind of hold back because we would just be hurting ourselves as a country if we showed, we'd be showing weakness if we went ahead and impeached the president. Of course, there's always the counter argument, right, that A, that's just a scare tactic, and B, that actually it ignores the fact that there might be things the commander-in-chief is doing that are undermining national security, right? And part of the heart of the Ukraine allegations are that the president was undermining national security for personal gain. So it is interesting to think if there isn't a rally around the president effect in this context, if maybe that kind of argument would have less purchase here. And maybe, in fact, the counter-argument that actually this just shows what a dangerous war we're living in and how important it is to put a stop to things the president may be doing to enrich or improve himself that harm national security. So it's possible this could sort of break from the classic model of the rally around the flag effect we'd expect.
So since we started about 5 minutes late to allow the trickle in from classes that ended right before the event, let's take these last 2 questions and then we'll wind up.
Hi, my name is Nathan Morse. I'm a political science PhD student. So I've heard some people suggest that if the Senate were to use a secret ballot, then perhaps the president would be removed. It'd be more likely, at least in that case, since senators wouldn't face backlash from their constituents. So I'm wondering, do you think that could actually happen? Is there any precedent for that? And what are the pros and cons of that?
So I don't think it would happen and I guess so. I'm thinking about just as a purely practical matter real quickly in terms of like what rules would apply, right? So it's possible that the normal rules in Article 1, Section 6 for Senate journals, which essentially it's a provision that essentially makes it pretty easy through, I think it's majority vote, for members of the House to call for proceedings, particular votes, etc., to be open. That might apply. Conversely, maybe special rules. The Senate might, default to sort of special rules for the impeachment process. That might apply. But one way or another, I think it's very unlikely that you'd have majority support for a secret ballot. I actually think it would be a terrible idea. It's really interesting because this does show, one benefit that's often touted of secrecy in government is that it does allow people to engage in sounder decision making because they're not worried playing to the crowd. And obviously that's what the secret ballot arguments are getting at. And that may even be true, right? That it may be that the senators who would vote to impeach on a secret ballot really believe this would be in the best interest of the country, but there's a conflict between that and their partisan political interest. That said, at the end of the day, any decision is so momentous. I think just it would be more dangerous to the democratic system to allow that to proceed through secret ballot, whereby each senator has to openly stand by their decision and face the political consequences. I think it would be more damaging to sort of get rid of that than it would be to allow it to proceed, even if it would lead to what some, omniscient overseer might say is an objectively sounder result.
Certainly inconsistent with the precedent about how Senate trials have occurred in the past. It's inconsistent with current Senate rules about that ought to govern a Senate trial. I think it also undermines one feature of what we think would be important in this context, which is accountability for legislators. And that's maybe particularly salient in the context of presidential impeachment. Maybe we think that would matter less in the context of some district court judge, for example, who might be impeached. But especially in the context of the possibility of removing a president, both those who are voting to acquit the president, but also those who are voting to convict the president, ultimately have to go to their voters and justify their vote and explain the rationale for what they're doing. And so when we think about this argument that the people of my state deserve to be represented, part of that as well is the people have their say at the end of this process, and they don't like what their particular representatives have done in this process, either in the House side or in the Senate side. There's a vehicle for punishing them and putting somebody in place that you think might behave better in the future on this front.
Thank you.
Hi, my name is Jed Matthews. I teach here at the law school. Could you speak a bit about the role of the Chief Justice presiding over the impeachment? Do you anticipate a lot of difficult decisions having to be made? And if so, what? And if he were here, do you have any advice for him on how to discharge that role in a constructive way?
So the Chief Justice's role is very minor. All he can do is act as presiding officer, and ultimately any decisions he makes can be overruled by a majority. I would anticipate that he will try to minimize his role as much as possible. Chief Justice Chase, sitting in on the Johnson impeachment, did not play a very significant role, although he did cast a few controversial votes and did make a few efforts that were relatively controversial. And part of what Chase was concerned with doing is trying to emphasize to the Senate that they shouldn't be hyper-partisan and try to take the process a little more seriously. Chief Justice Rehnquist somewhat famously said after the impeachment, his job was to do nothing, and he did it very well. And so I expect Roberts to try to do the same thing, that he would like to be a wallflower as much as possible.
Yeah, if I'm Chief Justice Roberts, I would hope I would see some dark cosmic humor in the fact that, the Chief Justice who so desperately wants to convey to America that we are not, as judges and as justices of the Supreme Court, partisan actors. I mean, he's, made some rare public speeches to this effect just recently, that I find myself presiding over the impeachment trial. And I have no doubt that he does want to be as much of a wallflower as possible. That said, I'm not sure that he will be able to avoid tough decisions, because you're absolutely right, a majority can overrule him. Doesn't mean that the initial decision won't, if he is asked to rule on, whether particular witnesses should be called, whether particular evidence should be deemed admissible, even things that might seem procedurally mundane, but that could have important substantive consequences. He may be in a position where he does have to issue rulings, which then, will put pressure on particularly sort of the wavering Republican senators, right? If he does issue some rulings that might be seen as undesirable to the president and his defenders, it's going to be hard if you're Mitt Romney, you're Susan Collins, you're Lisa Murkowski, to feel comfortable with voting to override, the vote of Republican appointee Chief Justice presiding. So anyway, I have no doubt he does want to be as much of a wallflower as possible. It'll be interesting to see if that does play out, though.
I believe procedurally it's possible for him to completely duck all those issues. I believe he does not actually have to make an initial ruling on any of these motions. It's possible for him to go directly to ask the sense of the body and have the senators cast the vote without the Chief Justice casting an initial vote and then pitching it in terms of the possibility of overruling his vote. And I think that both Chase and Rehnquist made that move at various points during those trials, although I'm not 100% confident about that.
Yeah.
So I want to give each of our speakers a little token of appreciation from Penn State Law.
Thank you.
Thank you.
And could everyone, I want to thank all of you for being here, and can you all please join me in thanking Professor Kitrosser and Professor Whittington.